Good morning, everyone. My name is Mann Heyy, and the purpose of this video is to provide some advice, some public international law advice to the Prime Minister of Mandalor on a couple of issues. On the facts, the state of Mandalor planning to become a party of the International Convention on Civil Political Rights (ICCPR), and as a legal advisor, this video aims to advise the Prime Minister of Mandalor on two principal matters. First of all, explain what does the first optional protocol to the ICCPR provides for and its impact on Mandalor. Second of all, I will also advise the Prime Minister with regards to what is reservations and whether Mandalor can enter a reservation to the Article 1 of the ICCPR. Before going in-depth discussion with the above two matters, I find it necessary for me to first explain what is optional protocol. To put it simply, ICCPR is the main treaty, while the optional protocols to a treaty is an instrument that establishes additional rights and obligations to a main treaty. And such protocols enable certain parties of the treaty to establish among themselves a framework of obligations which reach further than the general treaty and to which not all parties of the general treaty consent, creating a two-tier system. And the reason they are termed optional because they are not automatically binding on the states that have ratified the main treaty. Instead, states must separately ratify or accede to each optional protocol to be bound by its provisions. And the optional protocol to the International Convention on the Civil and Political Rights of 1966 is a well-known example. Now, after knowing these fundamental principles, I shall now start with what does the ICCPR and the first optional protocol to the ICCPR provides for. Just a couple of key articles. Now, the ICCPR, together with its optional protocol, overall speaking, enables individuals to allege a violation of their rights by submitting a communications or a complaint to a human rights committee established under the ICCPR of independent experts nominated to monitor compliance with the provisions in the ICCPR. And this is specifically stated in Article 1 of the first optional protocol to the ICCPR, which allows individuals whose countries are party to the ICCPR and the protocol who claim their right under the ICCPR have been violated and who have exhausted all domestic remedies to submit written communications to the UN United Nations Human Rights Committee. And state parties to the ICCPR undertake to ensure that women and men enjoy all the civil and political rights in the convention on the basis of equality. And this is well illustrated in Article 26 of the ICCPR, which can be used to challenge discriminatory law in the nation whether or not they relate to the civil and political rights. And Article 26, in fact, somehow has certain mutual reinforcing relationship with Article 1 of the optional protocol, which was used on the basis of communication under the first optional protocol of the ICCPR, just like the case of Brooks against the Netherlands to challenge a social security law that discriminated on the ground of sex. And in the detail of this case, I will explain a little further in the upcoming slides. Now, in addition to all this key article, the Article 19, paragraph 2 of the ICCPR also once again affirmed that everyone enjoys the right of expression. What it means by expressions here includes the freedom to say, the freedom to receive, the freedom to import ideas of all kinds. However, Article 19, paragraph 3 of the ICCPR permits limitations on the rights recognized under the Article 19, paragraph 2. But those limitations must be, two important points, provided by the law and necessary for respect of the rights of reputations of others. Yet, one must keep in mind, exceptions are always exceptions, as stated by the Human Rights Committee in its general comments, which emphasize that when a party imposes restrictions on the exercise of freedom of expression, these may not put into jeopardy the right itself, and the relation between right and restrictions and between the norm and exceptions must not be reversed. Now, after discussing some of the key features or some of the key articles of ICCPR and its optional protocol, I believe it is good timing for me to explain a little bit the impact of such treaty to the country of Mandalor. And according to Christopher Harland, the ICCPR is an expanded hard law version of the 1948 Universal Declaration of Human Rights. In other words, ICCPR is a human rights treaty. And Johanna Fornio also mentioned that the scope of all human rights treaties is to implement human rights in domestic laws and practices. Hence, if Mandalor is to enter into the first optional protocol, certain areas of domestic laws and administrative system in Mandalor will undeniably be affected. Now, one of the greatest impact of adopting the ICCPR and its optional protocol undeniably is the existing discriminatory law in Mandalor may require amendments upon being a party of the first optional protocol of the ICCPR. As Article 26, as I mentioned earlier, of the ICCPR provides that all people are equal before the law and are entitled to equal protection of the law without discrimination. The Human Rights Committee has decided that Article 26 of the ICCPR prohibits discrimination in law or in fact in any field regulated by the public authorities, and that the scope of Article 26 is not just limited to civil political rights. And all of this is decided by the Human Rights Committee in the case of Brooks against the Netherlands. In addition to that, due to the consequences of the case of Brooks against Netherlands, Article 26 therefore covers the positive obligation imposed on states in regard to legislating and applying its legislation. The committee in the Brooks case also stated that the ICCPR does not require states to legislate in any particular area, but does impose an obligation should a party choose to legislate that the law be compatible with the ICCPR in substance and in application. In other words, effect measures must be taken. Reference is made to the case of Avellana against Peru in 1986, where the Human Rights Committee found that the application of Article 168 of the Peruvian Civil Code resulted in Ms. Avellana being denied equality before the courts and constituted discrimination on the ground of sex. The Human Rights Committee expressed the view that Peru was under an obligation to take effective measures to remedy the violations of the provision in ICCPR suffered by Ms. Avellana. It is not uncommon, in fact, that a country's domestic laws involve some laws that are discriminatory in nature. For example, in Malaysia itself, Article 8 of the Federal Constitution expressly provided that no discrimination against citizens is allowed. But there's an exception, and the exception is unless it is expressly authorized by the Constitution. There are in fact discriminatory law in Malaysia. There's a citizenship law which only allows the children that born overseas to a Malaysian father to obtain the citizenship by law, or in other words, to obtain the citizenship automatically. So if Mandalor have a similar or any other kind of discriminative laws, no matter on the grounds of sex, race, or religion, then Mandalor may need to make amendments towards the said discriminatory laws. Now I shall now start with the second matter, which is the reservation. To advise the Prime Minister of Mandalor on the matters of reservations of Article 1 of the ICCPR, there are a couple of underlying principles that the Prime Minister may want to take note of. First, what is reservation? For the sake of entirety, I will not provide the full definitions of the reservation under Vienna Convention on the Law of Treaties 1969, which is hereinafter may be referred to as the VCLT. And Article 2, Paragraph 1, Subparagraph D, expressly provided that reservation means a unilateral statement made by a state party whereby it proposed to exclude or modify the legal effect of certain provisions of the treaty in their application to the state. Now, I understand this may sound a little bit too technical, but to put it simply, a state wants to enter a treaty, but it does not want the whole country to be bound by all the provisions in the treaty. Hence, it would like to reserve some of the provisions of it. And in the said VCLT, Article 19 to Article 23 is specifically relevant to make reservations. Now, Article 19 of the VCLT expressly provided that a reservation may be made on signature, ratification, or on the occasion of any other act by a state give its consent to be bound by a treaty. However, one must keep in mind that a reservation is only permissible when it does not fall under any of the three kinds of reservation prohibited by Article 19 of the VCLT, which are the first one, subparagraph A, the reservation is prohibited by a treaty, and subparagraph B, the treaty provides that only specified reservations can be made, or C, which is in the cases of failing under subparagraph A and B, the reservation is incompatible with the object and purpose of the main treaty. Now, I shall now explain a little bit on each of the subparagraphs in order to make further explanation on whether or not such reservation of Article 1 of ICCPR can in fact be made. First of all, for subparagraph A, some treaties like the Statute of the International Criminal Court, Article 120, have provisions that do not allow any reservation to the treaty at all. Yet, as we've seen in the ICCPR, nothing from the ICCPR seems to have provided any express or implied prohibitions for the state party to reserve any part of the convention. Hence, the Mandalor decision to reserve Article 1 does not seem to fall under this particular subparagraph. Well, for the subparagraph B, to understand better, I would like to refer to the very good example of the second optional protocol of the ICCPR, which is aiming to abolition of the death penalty in 1989. Well, in this particular second optional protocol, It expressly permits only reservation that provides for the death penalty is permissible in the whole second optional protocol. However, looking into the facts again, Mandalor is intending to become a member of the first optional protocol of the ICCPR, and this convention also does not provide any particular provisions that only allows specified reservation on specified provision. So the Mandalor decision to reserve Article 1 also will not fall under this particular subparagraph. Moving on to the third subparagraph C of that purpose, which I believe is the key of the case today. And if the reservation is incompatible with the object and purpose of the treaty, then such reservation shall not have any legal effect. And to determine what amount to the object and purpose of a treaty, reference can be made to the International Commission Guide to the Practice on Reservation to Treaties, particularly paragraph 3.1.5, which is concerning the incompatibility of a reservation with the object or the purpose of the treaty. And a reservation is incompatible with the object and purpose of the treaty if it affects an essential element of the treaty that is necessary to its general tenure and in such a way that the reservation impairs the raison d'etre of the treaty. But here comes the issue how to interpret or how to understand what are actually the object and the purpose of the treaty when it's not expressly provided under the state treaties. And particularly in this case, it is the first optional protocol to the ICCPR. Now, in this regard, reference can also be made to the paragraph 3.1.5.1 of the International Law Commission Guide to the Practice on the Reservations of Treaties, which provided a clear guidance, and it says that determination of the object and purpose of the treaty and the object of the purpose of the treaty is to be determined in good faith, taking account of the terms of the treaty in their context, and in particular, the title, the preamble of the treaty. Taking into the considerations the name of the treaty, which is International Covenant on Civil and Political Rights. And the preamble of the first optional protocol of the ICCPR allows people to complain directly to the Human Rights Committee if they believe their rights have been violated, which makes it undeniably an essential part of the treaty. And aside from this, even in mother treaty, in the main treaty, which is the ICCPR itself, the preamble, particularly the first and the fourth paragraph, which I quote, considering that in accordance with the principles proclaimed in the Charter of the United Nations, recognition of inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace of the world. And the fourth paragraph, I quote, considering the obligation of states under the Charter of the United Nations to promote universal respect for human rights and freedoms, respectively. Now, it is safe to assume, in this regard, that the object and purpose of the treaty is to protect one's inherent dignity and of the equal and inalienable rights, and most importantly, to promote universal respect for human rights and freedoms. And Article 1 of the first optional protocol provided that a state party to the convention recognizes the competence of the committee to receive and consider communication from individuals subject to its jurisdiction who claim to be a victim of a violation by a state party of any of the rights set forth in the convention. The express wording of this Article 1 of the optional protocol clearly reflects the essential rationale of the whole optional protocol. In other words, Article 1 is the object and the purpose of the whole optional protocol. And this can also be reflected by the previous cases decided, as I cited earlier, which is the Brooks against the Netherlands, the case of Adenana against the Peru case, where all of them they make reference to not just Article 26, but also Article 1 of the optional protocol, the first optional protocol, which allows the individuals from the state parties country to bring a communication to the Human Rights Committee. And the fact that as of September 2019, the first optional protocol has up to 116 parties, and none of these parties has ever made a reservations on the Article 1, which further substantiated the fact that Article 1 is the object and the purpose of the whole treaty itself. Therefore, if Mandalor is to make the decision to reserve Article 1 of the ICCPR, most likely such reservation is incompatible with the object and the purpose of the treaty, which is the ICCPR, making itself not valid. Last but not least, I would like to thanks to everyone's time in listening to these presentations. And here are essentially the references that I have made in the whole presentation. Thank you.